Okay, so it looks as though most people have joined now, so I'll get started. So I'm Rachel Rann, and I'm going to be delivering the session today on abandonment. For those of you who don't know me, I'm a chartered legal executive in the housing and regeneration litigation team here at Forbes Solicitors. I deal with housing management, antisocial behaviour, and disrepair matters. So this session will specifically cover what is meant by abandonment, how to deal with cases where the tenant is suspected to have abandoned the property, and I will also discuss some case law and look at a couple of case studies of cases that Forbes have dealt with in the past and one that's ongoing as well. So what are we dealing with when we are talking about abandonment cases? Put simply, it's when a tenant or tenants are no longer residing at the property as their only or principal home. In some cases, it will be clear that a tenant has abandoned a property. The property will have been cleared of furniture and personal belongings. There will be situations, however, where a neighbour may report having not seen a tenant for a period of time, or a landlord may have had difficulty contacting the tenant. However, when attending at the property to investigate, the property may still be full of furniture and personal belongings. Social landlords will usually have a clear policy and procedure in place for dealing with cases of suspected abandonment. Landlords need to act with caution, as it is important that locks are not changed prematurely and properties cleared, or a landlord may be faced with a claim for unlawful eviction and/or a claim for damages for any belongings which have been disposed of. In some circumstances, it will be really clear that a customer has abandoned their property. However, it's still important that the correct procedures are implemented to ensure that your procedure is consistent and lawful. Now, there are several reasons why a tenant may leave a property for a period of time. Firstly, this may be due to health reasons. For example, a tenant may have to spend a long period of time in hospital, or they may be residing in a care home, which can be short-term or longer term. The tenant may be fleeing a domestic violence relationship, or there may be alternative domestic arrangements. For example, a tenant may temporarily move out of the property to care for a relative. As well, a tenant may move out of the property for a period of time due to working away from the property. In all these cases, the tenant should be getting in touch with their landlord to advise them they're going to be away from the property for a period of time. There are clauses in most tenancy agreements that state if the tenant is to be away from the property for a period of 28 days or more, they should advise their landlord. But as we know, this doesn't always happen. So when reviewing cases involving suspected abandonment, it's very important that the landlord has taken steps to properly investigate whether the tenant has really abandoned the property. So some signs that a property has been abandoned may include reports from a neighbour stating they haven't seen the tenant or tenants for a long period of time. They haven't seen anyone going in or out of the property for some time. Home visits that suggest the property is empty. Escalating rent arrears. So no access for gas servicing or periodical electrical safety checks. Any reports from external agencies. The customer having initiated a termination of the tenancy, but then failed to return the notice to quit or their keys. So social landlords should be considering the following during any investigation into the abandonment. So attempting to contact the tenant using as many different ways as possible. So this is one of the most important things to show that the court, if proceedings are then issued, that you've taken all reasonable steps to get in touch with the tenant. So for example, this may be by phone, email, letter. In addition, if the tenant has a next of kin listed, it would be advisable for the landlord to try to contact the next of kin as well. However, just a note to be careful, as the tenant must have given you permission to contact the next of kin regarding their tenancy. So property inspections, visiting the property at different times over a number of days, looking for mail piled up by the door, whether there's rubbish in the bin, whether the garden is overgrown, whether there are any windows open, whether there are any other signs of life. So when going to the property to carry out the property inspections, it would be advisable to take photographs of both the inside and the outside of the property if possible, to keep a record of the dates the photos were taken, and obviously to keep all of these, all of the photos, all of the steps taken. Need to make sure the landlord's recorded all of this. So next we've got speak to the neighbours. So speak to the neighbours and check when they last saw the tenant, whether they've noticed anyone else coming in and out of the property. If the landlord can gain access to the property, which won't always be possible, to check the contents of the rooms, the fridge, the cupboards, bins, any sign that someone has been there recently. And again, to take photos and document the contents. And then finally, if you can access utility information, does the usage suggest that someone is occupying the property? Don't know whether we've skipped through ahead here. So, sorry. So you should consider all the circumstances in the case before deciding whether to treat the case as a case of abandonment. So the following list is not exhaustive, but it's a good place to start when thinking about the circumstances. So how long has the property been empty for? Whether the rent is still being paid, whether the tenant has left behind any belongings, the value of those belongings, and whether any evidence, and whether they evidence an intention to return to the property. So the tenant's current circumstances, including whether you're aware if they've secured new accommodation and the nature of that accommodation. The tenant's personal circumstances, so this will include any information the landlord has about any vulnerability or disabilities a tenant or the former occupier is under. So if appropriate, any explanation given by the tenant as to why they're not living at the property and any other relevant information. So it's very important for a social landlord to follow their policy and retain clear records so that if the tenant were to return to the property after it had been cleared and relet, they could prove that the tenant was no longer occupying the property as their only or principal home and would be able to defend any possible legal action. So in terms of procedure, if after investigations have taken place and the landlord has followed their policy, you're satisfied that the property has been abandoned, they can then take the following steps to recover possession of the property. So firstly, the first step would be to serve a notice to quit at the property. So if the landlord is satisfied that the tenant is no longer residing at the property as their only or principal home with no intention to return, they will have lost their security of tenure. They can serve a notice to quit on the tenant. So the second thing that the landlord needs to take into account is that they must comply with Part 3 of the pre-action protocol. So as serving a notice to quit is mandatory possession, landlords must comply with Part 3 of the pre-action protocol. If there is believed to be any occupiers remaining at the property, you'll also need to comply with the pre-action protocol in respect of any occupiers and provide them with a copy of the notice to quit and the opportunity to put any circumstances forward as to why they should be allowed to remain in occupation of the property. So we're now going to look at security of tenure, notice to quit, and Part 3 of the pre-action protocol in more detail. So firstly, I'm going to talk about security of tenure. Security of tenure means the tenant has the right to continue in occupation until the court has granted a possession order. So security of tenure for assured tenancies is set out in Section 1.1 of the Housing Act 1988. So it provides that a tenancy is assured if and so long as A, the tenant or joint tenants are an individual, and B, the tenant or at least one of the joint tenants occupy the dwelling house as his only or principal home. For secure tenancies, Section 79.1 of the 1985 Act accords a contractual tenancy secure status at any time when all of the conditions are set out are satisfied. So Section 81 of the same Act sets out the tenant condition, which is the tenant is an individual and occupies the dwelling house as his only or principal home, or where the tenancy is a joint tenancy, that each of the joint tenants is an individual and at least one of them occupies the dwelling house as his only or principal home. So in practice, this means that a tenant may lose assured or secure status if they do not satisfy one of the conditions, i.e., that they are failing to treat the property as their only or principal home. However, be aware that they can sometimes become assured or secure again on its subsequent fulfillment, i.e., if they do move back into the property. Therefore, if a social landlord seeks possession on the basis that the tenancy has lost protection and the contractual tenancy has been determined by a notice to quit, it's crucial to consider whether the tenant was in or out of the protection of the relevant Housing Act at the date of the expiry of the notice. So I know we had a lot of questions submitted before the webinar about repeated abandonments. So I'll come to that at the end. But this is crucial, whether the tenants were living back at the property at the date of the expiry of the notice to quit. So as said previously, an assured or secure tenant may lose their assured or secure status at any time by failing to satisfy the necessary conditions for assured and secure status that have been described. Therefore, in a wide variety of situations, the social landlord may be able to proceed on the basis that security of tenure has been lost. It will then terminate the tenancy by serving a notice to quit while the tenancy is without security of tenure. So an assured or secure tenant's absence from a property, however lengthy, does not in itself bring the tenancy to an end. However, the security of tenure of such a tenant may be placed in jeopardy by a long-term absence. This is because an assured or secure tenant retains security of tenure only for so long as the tenant or one of the joint tenants occupies the dwelling house as his only or principal home. If this is not the case, a social landlord may then serve a notice to quit to bring to an end the unprotected tenancy. Many tenants of social housing are temporarily away from their homes from time to time, on holiday, receiving medical care, working away from home. Some tenants may be absent for long periods, perhaps many years. This can arise when a tenant is, for example, imprisoned. Long absences may give rise to the inference that security of tenure has been lost as the tenant is no longer occupying the property as their principal home. So I'm now going to look at a couple of case law examples. So the first one is Crawley Borough Council in Sawyer. So in this case, the tenant was away from his home for over a year. The gas and electricity at the property had been disconnected. The tenant had moved in with his girlfriend and they intended to buy a property together. The council served a notice to quit. The couple's relationship broke down and the tenant moved back to his home. The county court judge held that the council property had throughout remained his principal home, and the tenant had always intended to return to it. The Court of Appeal did not interfere with that finding. So another case, Jennings v Epping Forest District Council. So in this case, the tenants, an elderly couple in failing health, left a council home and took a flat near to their daughter's home. When the husband's health started to deteriorate, he was admitted to a residential care home. His wife stayed in the new flat to be with him. The trial judge had no difficulty in finding that security of tenure in this case had been lost. The judge stated that he believed there was no prospect of or intention to return to the original home. So in Hammersmith and Fulham, London Borough Council v Clark, the tenant signed a notice stating they were a permanent resident of a nursing home and no longer intended to live in the house. The tenant subsequently returned to the property and was again living in the house. She gave evidence that she had been depressed at the time she signed the note because of difficulties with her medication. She said that she had always intended to return to the property once she was able to do so. So, considering the issue of whether a person occupied the premises as his or her only or principal home, even though not living there, the court will focus not on fleeting changes of mind, but on the enduring intention of that person. So in this case, the judge stated that it was particularly so in cases such as that before him, where the tenant was an old lady in poor health, whose intentions in the nursing home may well have fluctuated from time to time and even from day to day. So this is the leading case that deals with abandonment. This is London Borough of Islington and Boyle. So in this case, the local authority had granted B a secure tenancy of a property, and she lived there with her partner X and children. The relationship deteriorated and X moved out and bought a house. Their eldest child was severely autistic, and in 2004, in view of his aggressive conduct and inappropriate behaviour, B and X decided that she and her daughters would move out of the local authority property to X's house, and X would live in the local authority property with their son. The onus is on B to establish that she had a long-term intention to return to the property and to occupy it as her sole or principal home. So this case set out a number of factors to be taken into consideration when looking at whether a tenant has an intention to return. Firstly, absence by the tenant from the dwelling may be sufficiently continuous or lengthy, or combined with other circumstances as to compel the inference that, on the face of it, the tenant has ceased to occupy the dwelling as his or her home. In every case, the question is one of fact and degree. So, assuming the circumstances of the case and the absence as such to give rise to that inference, the onus is on the tenant to rebut the presumption that his or her occupation of the dwelling as a home has ceased. In order to rebut the presumption, the tenant must have an intention to return. While there is no set limit to the length of absence and no requirement that the intention must be to return by a specific date or within a finite period, the tenant must be able to demonstrate a practical possibility or a real possibility of the fulfillment of the intention to return within a reasonable time. So the tenant must also show that his or her inward intention is accompanied by some formal, outward and visible sign of the intention to return, which sign must be sufficiently substantial and permanent and otherwise such that in all the circumstances it's adequate to rebut the presumption that the tenant, by being physically absent from the premises, has ceased to be in occupation of it. So other reasons why the tenant may be absent for a long period of time, but may still have an intention to return. So a tenant's imprisonment. The case of a social housing tenant who is sentenced to imprisonment is relatively straightforward because they can be promptly located. They'll have left belongings at the property and they will usually state an intention to return even when serving a lengthy term. So elderly tenants in a home. The case of very elderly or mentally ill tenants in a caring institution is more problematic, as it can be difficult to establish that they have both the intention and the realistic prospect of returning to resume occupation at that property. So, tenants with two homes. The tenant loses security of tenure if their home in social housing is neither their only or principal home. It's a question of fact in relation to tenants with two homes, which can arise when they're also staying with partners, for example. Which of the properties is the principal home? In deciding which of the two homes an applicant occupies as his or her principal home, the case of Simagova and McMahon stated that where a person sleeps is a factor of the utmost importance. So moving on to notice to quit. So once a landlord has established that the tenant is no longer residing at the property as their only or principal home, they have no intention to return to the property. Therefore, they have no security of tenure and notice to quit can be served. So notices to quit are covered by the Protection from Eviction Act 1977. The Act states any notice to quit must be given 4 weeks' notice, include the prescribed information and be in writing. The notice to quit must expire on the last day of a period of the tenancy agreement. So a valid notice to quit can't be withdrawn, extended, or waived. When the notice to quit expires, the tenancy will end. So with regards to abandonment cases specifically, so the notice to quit must always be addressed to the tenant and not to any occupiers. It would be advisable for the landlord to send copies of the notice to quit to any other addresses they have for the tenant, including an email address. Even if the landlord knows the tenant is not at the property, the tenancy agreement will likely specify that this is where any notices should be served. So if you don't serve the notice to quit at the property, there could be an argument that it hasn't been served at all. The best practice would be for the landlord to hand deliver the notice to quit to the property as the time runs from the date the notice to quit is received. Therefore, if the notice is hand delivered, you know it was served on the day it was hand delivered, provided this was before 4 p.m. This means there cannot be any arguments about when it was served. Sorry about that. That was just our fire alarm test. So moving on to the next slide, we've got the pre-action protocol for possession claims by social landlords. So because any possession proceedings brought against the defendant in reliance upon a notice to quit will be on mandatory grounds, landlords need to comply with Part 3 of the pre-action protocol for social landlords, which deals with mandatory possession. What this means is that the defendant needs to be invited to make written representations as to their personal circumstances or any other matters they want the landlord to take into consideration before bringing a possession claim. It's not necessary to do this at the same time as serving the notice to quit, but it would need to be done before any possession proceedings were commenced. So it makes sense to include this request within the covering letter enclosing the notice to quit. And we would usually give the tenant 2 weeks to make the written representations. If the defendant responds, the landlord would need to respond in writing to confirm why they are still proceeding with possession. Confirmation that this took place needs to be included in any witness evidence and particulars of claim. Failure to comply with the pre-action protocol, especially when seeking possession on mandatory grounds, is likely to lead to the court striking out the claim for possession and, in some cases, ordering costs in favour of the defendant. So moving on to notice seeking possession. So failing to live in the property as their only or principal home is a breach of most tenancy agreements. Therefore, we would often advise clients to serve a Ground 12 breach of tenancy NOS on the defendant in addition to and or in the alternative to the notice to quit. This is to protect the landlord's position if, for example, there was any issue with the notice to quit, or specifically in abandonment cases, if the tenant returns to the property after proceedings have been issued. When preparing the notice seeking possession, you could also include any other grounds such as rent arrears and antisocial behaviour, which may be applicable. As usual, we would need to check that rent possession proceedings haven't already been brought against the defendant and that they don't already have a possession order that has been adjourned or suspended on terms. So by serving a notice seeking possession as well as the notice to quit, it protects you in cases such as repeat abandonments or when you've issued possession proceedings, you've got a court hearing, but the tenant has then got in touch. They've stated that they want to return to the property. They may have returned to the property and be living in it prior to the first hearing. So at that stage, the notice to quit kind of falls away because they are back at the property. However, if you have served a notice seeking possession as well, you can still rely on the notice seeking possession to continue the possession proceedings. So this brings me on to further considerations. The main one being the proportionality and the Equality Act. So landlords need to consider the proportionality of their decision to initiate possession proceedings. When relying on a notice to quit, we're seeking possession on a mandatory basis. So we need to carry out a proportionality review or a Proportionality and Equality Act review if the tenant has any known mental health or physical disabilities. This will allow the landlord to consider whether or not it's appropriate in the circumstances to pursue possession proceedings. If possession proceedings are also issued, it also shows the court that the landlord has acted reasonably and proportionately. So the other things on this list, such as offering a new tenancy of the property, offering suitable alternative accommodation, that would apply more when there are occupiers left in possession of the property. So, I mean, specifically in abandonment cases, those wouldn't be things that you would look at because the property has been completely abandoned. There's no one living there. However, in cases where there may be an occupier that's been left in occupation of the property, it is things to consider whether you could offer them a new tenancy of that property or whether you could offer them suitable alternative accommodation. So the other thing is to delay bringing possession. So I think specifically with abandonment cases, you want to ensure that possession proceedings are not issued prematurely. You want to ensure that you've given enough time for the tenant to return to the property, to get in touch. So that is definitely something to consider when dealing with abandonment cases or cases of suspected abandonment. So the above considerations, they will help to persuade the court that the landlord's decision to bring possession proceedings is proportionate and that the landlord has complied with their duties under the Equality Act. Ultimately, with mandatory possession, the only defence tends to be that the landlord has acted disproportionately or that they have discriminated against somebody because of disability. So one of the other main issues with properties of cases of suspected abandonment is if goods have been left at the property. So if you suspect that the tenant has abandoned the property, and there are goods left at the property, they may still wish to claim the goods later. It is the responsibility of the landlord to ensure that the goods remain safe. So goods or chattels left behind in a rental property are protected by the Torts Interference with Goods Act 1977. So in simple terms, this means that you can't dispose of any items left at the property immediately, even if that would be the easiest solution to the problem. So anything left behind by a tenant still belongs to them. Therefore, removing such items is unlawful and could land you in a lot of hot water. So, of course, as a landlord, you'll be motivated to clear out the property and install new tenants as quickly as possible. So, what steps do we take? So, a written letter is the best place to start. However, this is obviously difficult if we don't have a new address for the tenant, which is usual in abandonment cases. So, I mean, if you can write a letter, or it can be sent by email if you've got an email address for the tenant. So you can explain in the letter or the email that you're wishing to dispose of the items. So you must inform the tenant on how to contact you to retrieve the items. As well as this, you should include a detailed description of the items, where they're being stored, and when you'll be selling or disposing of them. Now, you've got to be sure to allow the tenant enough time to take preventative measures. So you should give your tenant the chance to rectify the situation and always keep a copy of the letters, the attempts made to contact the tenant. Always keep copies in your records. So the goods themselves must be stored in a safe place until reasonable steps have been taken to trace the tenant. So this can be either at the property itself, or obviously if you're wanting to recover possession of that property to relet it in a separate location. This could be a secure garage, shed, storage facility, basically anywhere that is secure. So you will need to prove that you've made reasonable attempts to get in touch with the tenant, should the tenant in the future try and bring a claim. So the notice itself should be sent to the tenant's current address if known, as well as attached. Sorry, when I refer to notice, I mean a torts notice. So the torts notice should be sent to the tenant's current address if known, as well as attached to the property in case the tenant returns to collect his goods. So it would be sensible to stick the notice to the inside of a window adjacent to the front door so that it's clearly visible if the tenant does come back. So again, the notice must contain the following information: the location of the goods, if the goods are to be sold, the location of the sale, notification that sale and storage costs will be deducted from the proceeds of any sale should one take place, and a list of items being stored. I think it's also good practice to take pictures of all the items being stored as well. That way, there can't be questions over whether something's happened to the goods whilst in storage, if any damage has been caused or if they've deteriorated. So if you have managed to get hold of the tenant and they give you permission to dispose of or to sell the items, then you can go ahead and do that. So in that instance, you'll want to make sure you have a record of any conversation that's taken place so the tenant can't later accuse you of unlawfully selling or disposing of their items. So if you can't get hold of the tenant or they haven't given you explicit permission to sell or dispose of their belongings, then the landlord can sell the uncollected goods if the following applies. So if the tenant has failed to collect their goods after the period specified in the schedule to the notice, and the landlord is unable to contact the tenant because they left no forwarding address, and any reasonable attempts to find them have been unsuccessful. However, it would be very careful in selling the goods. You'd always want to give a reasonable period of time. And I know that in some cases, this has been up to 6 months holding the items. So the proceeds from a sale of uncollected goods don't go straight into your pocket. You must account for the money in a proper manner. You deduct your costs from the sale proceeds, so the costs include storage, sale fees, etc. If the tenant owes you money, this debt can be deducted from the remaining balance. Any money left over must then be returned to the tenant, even if you still can't find them. So you must keep this money aside for the tenant for at least 6 years. Okay, so I'm now going to go through a couple of case studies. These are case studies that Forbes have dealt with fairly recently. One was dealt with a few years ago, and the other is still ongoing. So the first case study. So the landlord suspected the tenant was not residing at the property as their only or principal home. So there had been previous occasions when the tenant was suspected to have abandoned the property, but she had been in touch prior to any further action being taken. So between the 6th of March 2018 and the 25th of April 2018, the landlord called the tenant on one occasion, visited the property on 3 occasions, leaving calling cards, and wrote to the tenant by letter. So a notice to quit was served at the property on the 25th of April, as no contact had been received. So prior to the notice to quit expiring, 3 further visits were carried out at the property with calling cards left on 2 occasions. A lock change was authorised on the basis the property had been abandoned and the tenancy had been terminated. So the lock change took place on the 29th of May 2018. During the inspection, it was noted the letters and calling cards posted remained unopened. In addition, there was a bed, but no pillows or blankets, and a few clothes left scattered on the floor. The tenant got in touch with the landlord in July 2018, advising she had been living with her father who was unwell. The landlord, obviously by this time, the lock change had already taken place. So the landlord received a letter from the tenant's solicitor on the 25th of July 2018, which stated that the tenant was to pursue a claim for unlawful eviction and was seeking reinstatement to the property unless the landlord could evidence that its abandonment procedure had been followed. So the landlord's solicitor responded on the 15th of August 2018, enclosing a copy of the defendant's abandonment procedure and detailing the steps that had been taken by the defendant to terminate the claimant's tenancy. The letter requested a response within 21 days, otherwise the matter would be considered closed. No response was received, so the property was relet on the 14th of November 2018. The tenant, or the former tenant, brought a claim for unlawful eviction, which went to trial in July 2020. Now, the judge found that the tenant's claim for unlawful eviction was satisfied. The judge stated that he thought the landlord could have taken more steps to investigate whether the property had really been abandoned, and that he found that the tenant did have an intention to return to the property. The judge awarded damages of £10,050 to the tenant, and the landlord had to pay the tenant's cost of £26,000 and then £540 for a cost assessment. So this case just highlights kind of the risk of serving your notice to quit and then changing the locks without obtaining a possession order. So just bear in mind that there will be some cases where it's very obvious that the tenants abandoned the property and potentially will be deemed very, very, very low risk to do the notice to quit and change the locks. That's kind of a decision for individual organisations to take on individual circumstances on the case. But I think this case that we dealt with just highlights the risk in doing that, because obviously the tenant bought a successful claim for unlawful eviction and was awarded £10,050 in damages, and the landlord had to pay substantial costs as well. So this is the second case study that we've dealt with recently. So in 2021, complaints were made regarding the condition of the tenant's garden. The complaints continued throughout 2022 and 2023. The tenant last spoke to the landlord in April 2023, when the tenant advised he would clear the garden and bring it up to an acceptable standard. In August 2023, the tenant's DWP contributions towards his rent arrears stopped. In October 2023, the landlord opened a case for suspected abandonment. On the 17th of October 2023, a notice to quit was served at the property. In November 2023, the landlord visited the property to complete a final abandonment check. It was noted that there was no change in the condition of the garden, which remained in an overgrown state. The landlord had previously placed a piece of wood on the door. So when they returned to the property to complete the final abandonment check, they noted that the piece of wood the landlord had put in the door around 2 weeks before had not been dislodged, confirming that the tenant or no one else had been back to the property during that period of time. So in December 2023, a notice seeking possession was also served at the property without prejudice to the notice to quit. So a cover letter was served with the NOSP, which asked the tenant to confirm any personal circumstances or other matters which she would like the landlord to be aware of before any possession proceedings were issued. So at the same time, or as this was ongoing, because the landlord couldn't gain access to the property to carry out a gas safety check, injunction proceedings were issued for access for the purposes of a gas safety check. So the tenant failed to attend any of the 3 court hearings that were listed in relation to the injunction proceedings. On the 1st of February 2024, the landlord attended at the property with operatives, and they gained access to the property by forced entry as per the court's order from the injunction proceedings, which authorised forced access. So when they gained entry to the property, there was a lot of posts behind the door, a strong smell of paraffin coming from the living room. All the curtains were closed. There were 13 cannabis plants inside a metallic type of tent with a silver vent hose coming out of it and pointing to the bathroom. The police attended. So a notice was placed on the door for the tenant to contact the landlord to obtain a new set of keys for the lock. So on the 16th of February 2024, the claimant received a call from the tenant's neighbour to say the kitchen window at the property had been smashed. The neighbour also stated that they had seen the tenant near to and inside the property. So by this time, possession proceedings had been issued. So in April 2024, the tenant contacted the landlord requesting access to the property and advising that he had been having issues with his mental health. So this case is due in court next month, so we don't have an outcome on this one as yet. However, I wanted to discuss this case because I think it highlights the importance of also serving a notice seeking possession of the property. When the court hearing does go ahead, if the tenant has moved back into the property, the notice to quit, the case in relation to the notice to quit is likely to be dismissed. However, as we have relied on the notice seeking possession as well, we can still ask the court to continue on to rely on the notice seeking possession, and we can still ask for a possession order in reliance upon the notice seeking possession rather than the notice to quit. So to summarize, in terms of the procedure, in terms of the abandonment procedure itself, if the tenant is failing to live at the property as their only or principal home, the landlord needs to ensure that they follow their policy to the letter so that this can be evidenced in any witness evidence. The landlord must prove the tenant has no intention to return, which, as we've seen from some of the case law, it can be difficult to prove. The landlord also needs to serve the notice to quit on the tenant, provide copies to occupiers if there are any, and comply with the pre-action protocol. It would always usually be my advice that the landlord should also serve a NOS for breach of tenancy and include any other relevant grounds. As previously discussed, this is so that the NOS can be relied upon in the alternative. Just be aware that the notices must be served without prejudice to each other. So I know there was a few questions that were submitted before the webinar. So I'm just going to go through a few of those quickly. So firstly, do you think we should always serve a torts notice for things left behind by residents if we believe them to have abandoned and are pursuing a notice to quit route? So I would advise that yes, you'd always serve a torts notice, just purely to reduce risk. If the tenant was to return to the property, they could always bring a claim for damages on the basis that the landlords disposed of their items, their goods, unlawfully. So yes, I think it's just a way of reducing risk. So I would definitely advise that a torts notice is always served when dealing with suspected abandonment cases. So the next question, what would be the likely outcome if a tenant had abandoned a property? Meter readings, witness statements all confirm abandonment, but they've returned just before the court date saying they always wanted to live in the property. So this is similar to case study 2 that we're dealing with at the moment. So it would depend whether a notice seeking possession had also been served. If the proceedings were brought just in reliance on the notice to quit, and the former tenant, attended at the court hearing, and said to the judge, no, I've been away for this reason. It is my only or principal home. I intend to return. Then it is likely, in our experience, not in all cases necessarily, but in our experience, it is likely that the case would be dismissed. And then you'd have to start again from scratch in reliance on the notice seeking possession. So if you've already served the notice seeking possession and you're pleading that, you're relying on that, on the notice seeking possession in the alternative, then it always will protect your position as a landlord if that happens and the tenant does advise that they want to return to the property. So there were quite a lot of questions on what we call repeat abandonment cases. So in case study 1, that was a case where prior to the locks being changed on the occasion I spoke about, there had been 2 or 3 other instances where the abandonment procedure had been followed, but the tenant had then got back in contact. So in relation to cases when a tenant is absent from the property for periods of time and only gets back in touch once a notice to quit is served, the landlord can consider going down the notice seeking possession route using ground 12. And So that's for breach of tenancy, and the tenancy breach would be obviously the tenant's not occupying the property as their only and principal home. However, obviously, if the tenant, so yeah, I mean, it's very difficult to prove a tenant is not living at the property if they do get in touch with the landlord. So as I keep saying, the notice seeking possession protects your position. In terms of, yes, one of the questions talks about repeat abandonments. They get in touch, but they're still not allowing access to the property. So in terms of gaining access to the property, the landlord should consider issuing injunction proceedings. I'd recommend taking that step before a notice seeking possession is served and before issuing possession proceedings, especially in cases where the tenant keeps getting back in touch. So if the tenant then fails to engage with the court process for the injunction and or breaches the injunction order by continuing to fail to allow access, this will only assist a possession case and add weight to the evidence that the tenant is not residing at the property as their only or principal home. So, got another question. So, is it always advisable to apply to the court for a possession order once the notice to quit has expired? And is it okay to serve, then rely upon a torts notice, change the locks, and then take back the property on suspected abandoned properties? So this, again, as I kind of alluded to earlier, this is a question of risk for each individual organisation to consider in the individual circumstances of each case. So we would usually advise that landlords apply to courts after the notice to quit has expired to obtain a possession order. That way, you're reducing the risk of any claim for unlawful eviction being made. However, as previously stated, there will be some cases where this is highly unlikely. It's highly unlikely that a tenant will return. So again, it's up for the organisation to take a view on that individual case. I think it's all about considering the level of risk you want to take. Because obviously from case study 1, we've seen what can happen if a notice to quit served, the locks are changed, and then the tenant comes back and does make a claim for unlawful eviction. So finally, there was a question about, can you use social media posts to prove to courts that someone is not using a property as their main or principal home? So yes, you can use social media posts as evidence. I'm not sure how good that evidence would be, depending on what's said and what the pictures are, if it's pictures. But it's certainly something that can be used as evidence in a case. So if there are any other questions, my contact details will be on the last slide. So if you want to get in contact with me, drop me an email or give me a call. Then I will try and get back to you on any questions I haven't had time to answer, or if you just want to discuss anything else, then just get in touch. So the next webinar in our how-to series is going to be with my colleague Laura Hanson on the 17th of July, and she's going to cover how to draft a persuasive statement. So thank you very much for your time today. As I say, if you've got any other questions, my contact details are on the slides, which will be sent round to you after the webinar. So please get in touch if you want to discuss anything we've discussed in this webinar further. And again, thank you for your time.